Hello, I'm Katherine Biber. I'm a visiting fellow here at the Institute. I'm also a visiting fellow at Birkbeck School of Law. I'm a law professor from the University of Technology in Sydney, Australia. And as a fellow of the Institute, I'm asked to give one lecture talking about the work that I've been working on during my time here. So that's what I'm going to do this evening. I'm going to talk for about 45 minutes and show a lot of images. And because I've been told to expect a kind of diverse audience, I hope there'll be some time to hear from you about your own interest in these topics, if you have interest in this topic, and any kind of perspectives you may have on it. I've written it to be accessible to a wide-ranging audience. It's not a kind of specialised legal paper, but I'm happy to advance any of the more specialised aspects of it if anyone's interested in that in discussion. I'm going to talk from over here only because I've got a lot of slides to show and it's easier to control them from here. And I've written the paper to be read, but if anyone has any pressing questions or clarifications along the way, I'm very happy for you to interrupt me. I kind of break out of my paper and talk a little bit about these images along the way. Is it all right with the lights on? Or? Right, thank you. So just to explain, the work that I'm doing here at the Institute is part of a 3-year funded project which is supported by the Australian Research Council, and I'm 2.5 years into that project. And about 2 years into the project, I thought that the project, which has this title, probably has a book in it. So now I'm under contract to write a book with a slightly different title that will flow from this project. And so what I'm going to present tonight is a series of questions or provocations that I've been asking myself, and that I'd like the book to at least have a go at answering those questions. And I invite any of you who have any answers to those questions for me to please offer them in the course of our discussion. So this paper emerges from a project in which I investigate what happens to the evidence tendered in criminal proceedings after the conclusion of the trial. It responds to the cultural proliferation of material that was previously tightly regulated. Whether from surveillance cameras or taken by crime scene investigators or found in the police brief of evidence, criminal evidence begins with an evidentiary purpose. The admissibility and use of evidence in criminal trials is governed by the rules of criminal procedure and the laws of evidence. The rules govern the acceptance, interpretation and effect of evidence when resolving disputed facts about criminal behaviour. But the rules of evidence do not operate outside the courtroom door, nor after the conclusion of proceedings. I'm investigating here instances where evidence has become untethered from the laws of evidence. This paper is about what happens when the rules of evidence run out and when this material returns to what I'll notionally call law's archive. This is a photograph of the Forensic Photography Archive in Sydney, Australia, and I've been told to say every time I show this photo that they no longer store these fragile glass plate photographic negatives in this way. But I prefer this photo to the way they store them now. Okay, so I'm interested in what happens when evidentiary material returns to an archive and when cultural workers put that material to fresh purposes. I'm interested in whether and how this evidentiary archive might be accessed, by whom and for what purposes. I wonder whether the formalities of the trial should endure, or whether in its cultural afterlife, criminal evidence might provide the basis for experimentation or enjoyment. I ask whether we should be worried that some of these post-trial deployments are willfully transgressive or insensitive. The material that I'll be showing you today, and a lot more material that I will not be showing you today, was in one context or another tendered into evidence. And please be aware that the material that I've selected to show, I've tried to select to illustrate some of my arguments, but not to shock or disgust or offend anybody. I have material like that, but this project is exploring some of my concerns about that kind of material. So all of the material that I'm showing you today was in one context or another tendered into evidence. All of it was obtained from official sources in different ways. These materials, having been dislodged from the judicial archive, are now the basis for various creative enterprises, including scholarly enterprises. Artists, curators, playwrights and academics regard evidentiary materials as compelling and rich subjects for our endeavours. Many of us explicitly acknowledge the problems or dangers of using evidentiary materials from official archives and putting them to fresh purposes. But some of us, and I include myself here, need to spend some time reflecting closely about how we deal with materials that, whilst publicly accessible, contain secrets. This reflection is demanded by an emerging cultural sensibility. Anne-Laura Stoller termed it the archival turn, and Hal Foster called it the archival impulse. Jacques Derrida diagnosed it as archive fever. And whilst they are not talking about the same phenomena, they are all talking about the process by which we create a fetish of the stored artefact or document. For artists, and also for lawyers, journalists, publishers, curators and scholars, the document in the archive has the attributes of authenticity, contemporaneity, and the unique tangibility of a real moment captured in material form. These attributes form the basis for the strict interpretive limits imposed by the rules of evidence and criminal procedure. These rules, of course, cannot hope to contain the other attributes of the archival document, those that motivate creative work, beauty, violence, surprise, shame, volume, and the promise that it contains an irresistible secret. Some of you may have visited the forensics exhibition that is currently showing at the Wellcome Collection. Subtitled The Anatomy of Crime, the exhibition explores the history of forensic science techniques as tools of criminal investigation and includes many objects, images and ephemera from that history, as well as cultural and creative works made from and about forensic criminal materials. In one cabinet, you can see a little jar of maggots floating in formaldehyde, retrieved from the homicide victims of Dr. Ruxton in 1935. In another room, you can put on headphones and listen to the sound recording of an autopsy conducted on a murder victim in Mexico. That's an instance of sound art made by the artist Teresa Margolis, who is also a forensic pathologist. As I sat there listening to the gurgling, bubbling and splashing sounds of this autopsy, and heard sirens and traffic in the distance, and later the sounds of cutting, slicing and hacking, I asked myself a series of questions that in this project I'm seeking to answer. What gives these materials their power? Does the significance of this material outweigh things like the dignity of crime victims, or the legal protections afforded to crime perpetrators, or the restraints of the rules of evidence? Why do I feel queasy or uncertain about exhibitions of this nature? Within that exhibition, visitors can see one of Francis Glessner-Lee's nutshells. The nutshell studies of unexplained death are a collection of at least 18 miniature dolls' houses made by Glessner-Lee sometime between the 1930s and 1950s in order to assist police detectives to learn techniques of criminal investigation. Based upon real cases and funded by her own substantial inherited wealth, Glessner-Lee's nutshells are still used in police training courses and are held at the Medical Examiner's Office at Baltimore, Maryland. The nutshells are astonishing for their attention to detail, for the skill with which they've been made, and for their extraordinary weirdness. So, for instance, she knitted these socks with 2 pins. That's how small these nutshells are. These are perfect dolls' houses, furnished, appointed, decorated, with the dolls either hanged or drowned or stabbed or shot dead. Whilst I was interested to see one of these nutshells out of its formal pedagogical context displayed at the Wellcome exhibition, I was already familiar with them through the work of the artist Corinne May Watts, whose beautiful photographs of the nutshell studies have been published in a lavish book, which is also available in the Wellcome gift shop. So that's the book. More recently, the nutshells have been the basis for a documentary film titled Of Dolls and Murder, directed by Susan Marks. Released in 2012, it has a voiceover recorded by Baltimore's most weird citizen, film director John Waters. And more recently still, they were the basis for a Radio 4 documentary made by the poet Simon Armitage, who has also written a series of poems about them. At a recent event at the Wellcome, Simon Armitage explained that when he first saw the nutshells, for their details, their stories, their frames, and their miniature size, he said they were what I thought of as poems. This interests me. When a non-lawyer, in this instance a poet, views evidence, they might see it in a way that is entirely unfamiliar to the law. Unfamiliar and sometimes uncomfortable. Can evidence be poetry? For Armitage, the nutshells were both playful and macabre, and combined weirdness and voyeurism. At that event, Armitage said something that I think might account for some of my unease about much of the afterlife of criminal evidence. The nutshells are kept in the Baltimore Medical Examiner's Office, which is where the forensic pathologists worked. Having accepted an invitation to watch an autopsy, Armitage reflected, I didn't feel queasy, he said, I felt uninvited. Criminal proceedings occur in public. It is this publicity that, articulated through the principles and jurisprudence of open justice, provides the qualities of accountability and transparency that is said to give us confidence in the criminal justice system. I have no quarrel with these practices or principles, and in another version of this talk I give a long and detailed defence of open justice. But I am investigating whether it is voyeurism or something more sinister that drives us, some of us, to use criminal evidence outside of the criminal process. Perhaps it's benign, perhaps it's ethically sound, perhaps it's significant, giving us powerful new insights into the processes that as lawyers we take for granted. Artists are not really interested in the jurisprudence about the authentication of documents or the distinction between logical and legal relevance or the exceptions to the rule against hearsay and so on. Having cultural practitioners reassess criminal evidence might offer us, lawyers, ideas we would never have had otherwise. But Armitage's hesitation that he felt uninvited struck a chord with me. Okay, we're now going to look at some film stills from a video artwork called Tea Room, which is by the American visual artist William E. Jones. The work is actually a video work, but I'm just going to show you some stills from that work that works technologically to show the video to an audience. So Tea Room is an artwork made from 56 minutes of covert surveillance footage filmed in 1962 by police officers in Mansfield, Ohio. Over the course of 2 weeks, 2 police officers concealed themselves behind a two-way mirror in a men's public toilet and filmed this footage. The evidentiary footage led to 38 arrests and the identification of a further 30 offenders and secured at least 31 convictions for sodomy, which at the time carried a mandatory minimum prison sentence of 12 months in a state penitentiary. Decades after the convictions were secured, by a process I've written about elsewhere, William E. Jones got a copy of this evidentiary footage. He made several minor but important adjustments to it, and he gave it the title Tea Room, which is archaic American slang for what in Australia we call a beat, and what in the UK is apparently called a cottage, a public place where men meet for illicit sex. He added his own name, William E. Jones, as the artist, and he is now the person in a position to grant permission to scholars like me who wish to write about and reproduce images from this material. So I obtained this evidentiary material from the artist who made an artwork from it, and I have his permission to show it, which is interesting in a kind of intellectual property sense as well. Jones is well known for his archive-based art practice, and his work has been screened internationally and in some very prestigious contexts. Within the domain of art, Tea Room is an act of appropriation, where a found or ready-made object is recontextualised by the artist and thus given fresh meaning and a new audience. Within the domain of the criminal trial, these criminal proceedings were public, the defendants were convicted and imprisoned, and they experienced the full weight of the trauma and humiliation of having their sexual secrets exposed. Does this entitle us today to open access to this criminal archive? Jones, in his own writing about his artwork, and his supporters in the queer and arts press say this footage teaches us a lot about the closet, about the policing of gay sexuality, about what sex looked like before mass pornography. These men went to a public toilet. They took an extreme risk, they committed crimes, and they were caught. The evidence against them was lawfully obtained. It was admissible, it was tendered in court, and it remains on the public record. But by viewing it now, are we participating in the popular contemporary practice of open justice? What kind of transparency or accountability does this artwork facilitate? One of the aims for my project is to put some pressure on the socio-legal discourses around openness and secrecy, transparency and sensitivity. How might we imagine a discourse that accounts for shame, indignity, regret, and how might it account for the passage of time and the accumulation or transformation of meaning that grows over time? How might it account for the fact that whereas I first sat down to watch Tea Room as a legal scholar examining a piece of criminal evidence, I ended up feeling like a voyeur and an intruder, and like I was now somehow entrusted to keep secrets for these strangers. Henry Borg is an English photographer and a scholar of psychoanalysis. He is the author of Laconic Scene, published in 2009 by the MIT Press. Borg visited the British National Archive and looked at English murder files from 1955 to 1970, in which the perpetrator was convicted. He had the idea that although these murders were solved in the judicial sense, there were extra clues that could be subjected to Lacanian analysis, which might yield some fresh, unanticipated view of these crimes. So this is a photograph of detectives investigating a crime, and this is the view of the victim looking towards the detectives. This is the victim looking down. So he's looking at the different perspectives that these images offer, and he analyses the images from a Lacanian psychoanalytic perspective. From the perspective of cultural studies scholarship, Borg's project is relatively uncontroversial, and he has the significant authority of Slavoj Žižek writing the series forward. Žižek describes Borg's project as taking existing texts, by which he means the closed murder case files, reading them through another apparatus, by which he means Lacanian theory, and, quote, making them readable in a totally new way. Borg's actual methodology is to use Lacan's diagnostic model, in which the patient is either neurotic, perverse, or psychotic, to classify these murders and their perpetrators, and to find within the police photographs evidence of this diagnosis. I've written elsewhere about whether he has succeeded in his aims. My conclusion is no. But for today's purposes, I'm more interested in what he has buried in one of his footnotes. He writes, quote, there should be a warning note on the cover of this book so that the casual viewer is prepared for the images therein. There is no such warning note, and it's hard to see how anyone could be prepared for the abject and degrading manner in which the book's photographs reflect the crime's victims. The photographs, and I'm not showing you most of the photographs in this book, the photographs are shocking, heartbreaking, and unforgettable, and I'm still quite angry about that book. Primarily, the images in Borg's books are the female victims of sexual and domestic homicide. He demonstrates no awareness that his book operates as an uncritical celebration of pornography of extreme sexual violence and humiliation. Or actually, he probably does know and he doesn't care. At times, he seems to be laughing. His writing, and of course his reproduction of over 100 of these evidentiary images, shows he has not even begun a process of thinking ethically about opening crime's archive. His book is crammed with meretricious taunts. For instance, at one point he writes, quote, do you not, gentle reader, feel a little dirty as you browse the lurid images? So this is a photo of a domestic homicide. This is a photograph of a sexual homicide. I'll talk about this one in a minute. This one, I like this one because, you know, it's kind of benign. But in this photo, and I won't say more about it except to describe it, this is a scene from a suicide. It was in a police archive because suicide at this time was a crime. And this suicide has left two notes. The note on the left, the longer note, is the suicide note, and the note on the top of that pile of books says, please return these books to the Fulham Library. And that's what Borg uses to diagnose this perpetrator as a neurotic personality type. So I'll just talk about this for a minute. Because whilst Borg has his defenders, and there are readers who have disagreed with some of my published criticism of his work, my view is that Borg's analysis, taken at its highest, operates as a kind of Lacan-light musing, shocking in its gynophobia by someone who fails to notice the seriousness of homicide. I'll just give one example. This woman was raped and murdered on a train in 1965, travelling between Sussex and Surrey. Borg reproduces many photographs of her body spread out on the floor of the train carriage, her clothing left in a humiliating state of disarray. We learn that the victims snubbed the perpetrator's sexual advances during the train journey, which Borg described as, quote, an inversion of the romantic notion of the chance encounter with a stranger on the train, unquote. Before launching into some psychoanalytic play with some graffiti that's on that train carriage, Borg writes, quote, finally these strangers did form a lasting relationship, but only as perpetrator and deceased. Part of my aim here is to try and understand what it is that makes Borg's use of the archive so objectionable to me, and why I'm so drawn to and impressed by Peter Doyle's project. I like this photo because it's a photo of his book in the context of books, so I'm going to talk about his book and the exhibition from which it emerged. Doyle is a scholar, crime writer, musician and curator who has now exhibited 3 major exhibitions of photographs taken by New South Wales Police and which are now in the custody of Sydney's Justice and Police Museum. I showed you a photograph at the beginning of that archive in the way that it used to be stored when it was first found. Doyle basically moved himself into the loft of the museum, spending years living with over 4 tons of filthy and uncatalogued photographic negatives and glass plates taken by New South Wales Police between 1912 and 1948. I'm just going to randomly put these images for a while. The archive, before it was rescued by the museum, had been moved from one premises to another, barely surviving a flood, vermin, and the ravages of time. The photographic plates had become separated from the documents and files that might once have explained them. This photographic archive has become untethered from the legal archive. Doyle now wonders whether they can be put back together again. He speculates about what these photographs mean, why they were ever taken, what crimes they seek to solve, and what else we might learn from the world from which they came. I've never met Henry Bond, but I have met Peter Doyle, and the fanatical gleam he has in his eye when he talks about these photographs seems compelling and entirely reasonable. He has plundered the criminal archive, and I'm grateful for what he has unearthed. Bond has done something similar, and yet I'm repelled by both his motives and his product. Between 2005 and 2006, the Sydney Justice and Police Museum exhibited City of Shadows, from which these images were drawn, curated by Doyle, accompanied by a large format book containing hundreds of the images. The second book, titled Crooks Like Us, continued in that vein, reproducing many more images, some with commentary, and both books won awards commending their physical presentation or production. These are what I can only think might be called coffee table books, lavishly illustrated volumes of historical mugshots and crime scene photographs, continuing a tradition probably inaugurated by Luc Sant and with which persists with what I have to assume is commercial viability for its publishers. There are plenty of examples of this genre on sale right now in the Chamberlain Collection bookshop. One of Doyle's aims is to compare the nature of photography and the nature of crime. Doyle is reminding us to look at the photographs not only as evidence of criminal facts at issue, but as evidence of human malice or misfortune, and as haunting memories of times, places, and people. The context in which he found these pictures, the police archive, already tells us that these pictures are criminal evidence. But Doyle is showing us another way of looking at them. These pictures represent the minutiae of the way people lived, housekeeping practices, products on shelves, private habits. I like this one. This is two teenage boys who were arrested in North Sydney, which today would not have teenage boys who look like this. It's a very kind of conservative business district. Once the facts in issue have been lost in time, these photographs can become evidence of something else, and Doyle seems to have exercised some judgment about when to solve a mystery and when to keep it a secret. It's one of my aims here to figure out what distinguishes City of Shadows as an example of a sensitive use of the criminal archive from Tea Room, the video artwork, as a deliberate act of artistic and socio-political provocation, and La Comet the Scene, which reflects an outright refusal to accept that with archival access comes responsibility. One of the questions I've been asking myself is what changes with the passage of time? Whilst the substantial principles of evidence and proof have changed very little, with time some of the more raw sensibilities and emotions of criminal harm might be tempered with new kinds of reflection. This is a photograph of a police detective investigating a fire at a strip club. And again, you wouldn't see photographs like this today in a similar criminal investigation. So with the passage of time, something changes, new meanings might accrue, new connections might be drawn, or socio-political preoccupations might have changed. Also, a new aesthetic emerges. One of the very interesting aspects of Doyle's work is his ability to see criminal images aesthetically. For him, these images are composed, framed, lit. They are the result of technical and aesthetic deliberation. Here you can see the photographer has carved into the plate, "This man refused to open his eyes." These photos show us a world that no longer looks like our own. People don't look like this anymore. They don't dress like this. Their poverty now looks less desperate and somehow charming. Does this change our relationship with these images, enabling us now to see aesthetic artifacts, as aesthetic artifacts images that were once procedural or evidentiary? In 2011, a number of the mugshots from City of Shadows were purchased by the fashion designer Ralph Lauren and were displayed in some of his flagship menswear stores internationally. And so I'm going to show you some photos from a collection that he released. He wasn't the first fashion world heavyweight to notice the powerful visual allure of these images. A few years earlier, Karl Lagerfeld from the House of Chanel was given the City of Shadows book, which was said to be inspirational to his design practice in that year. One of Ralph Lauren's diffusion lines, RRL, makes men's workwear, casual rugged clothing in neutral colours. His fall-winter collection in 2011 was based on City of Shadows, and the catalogue was an extraordinary aesthetic citation of Doyle's exhibition. Models wearing Lauren's clothing were styled to look exactly like the men in the mugshots and were superimposed onto the real backgrounds from those earlier photographs. So if you look here, you can see that the name of the accused was carved into the glass plate by the photographer. Those are the original names from the police archive, with the model superimposed onto the top. The real names of the original suspects remained etched into the fashion catalogue, confirming that there really is something compelling about the aesthetic effect of these images. Of course, this says nothing about the debates within the New South Wales Historic Houses Trust, which is now known as Sydney Living Museums, and which is the custodian of the Forensic Photography Archive. Their commercialisation of these images is a fraught subject within that institution. As a poorly funded public heritage agency, their board is comprised of both historians and bankers, and so the public display and the monetisation of this evidentiary archive has not been undertaken lightly. At his most recent exhibition drawn from the Sydney Police photographs, Doyle appeared to be testing some of the aesthetic attributes of criminal images. Suburban Noir, this is a photograph from Suburban Noir, opened in late 2013 at the Museum of Sydney. Curated from the most recent tranche in the archive, made in the 1950s and 1960s, these photographs come from the suburbs. Vacant lots, featureless streets, petrol stations, banal domestic interiors. These images show a world within the living memory of many of its contemporary viewers, and Doyle was trying to see whether they are showable in the cultural sphere. That word showable is something that Doyle is investigating. What is showable is an ongoing question for Doyle. My sense is that he believes everything is showable theoretically. In fact, he's really exploring how to make criminal evidence showable. How, given its original purpose, its content, its meaning, the dignity of the dead, the skill of the police photographers, its ongoing impact upon relations and survivors, its value for historians and other scholars, and of course the little visual fragments that grab us. These are what Roland Barthes would have called the punctum, that quality in a photograph to escape from its frame and pierce our sensibilities, attaching itself to us in some intimate way. Little clues or secrets, a way of arranging one's things on a bedside table, or a surprisingly great pair of shoes, a facial scar, a certain look in the eye. I'm just going to see if this works. I'd like to show you just a 1.5-minute trailer of that exhibition, which hopefully you will also hear is voiceover narrative. Because the voiceover narrative is included in the exhibition.
Back in the 1950s and 60s, while regular photographers were snapping away at the beaches, the harbour, the better homes and gardens of go-ahead Sydney, police photographers quietly, steadily, dutifully building up a record, a picture of the other Sydney, the troubled spots of Sydney, the crime and accident scenes, the sprawling fibro suburbs, the new houses, the shabby furniture, dirt roads, weak interiors, the way most people in Sydney lived back then. A few years ago, thousands of these amazing, raw, intimate images came to light. Suburban Noir presents more than 200 of these extraordinary images. To help us make sense of them, we invited 15 contemporary artists to respond to that selection. Together, the photos and artworks present a surprising, raw, complex, gloves-off view of the Sydney that really was in the 1950s and 60s.
Right, so as he's just said, to test the kind of affective power of these photographs, 15 contemporary artists were invited to create works that responded to the photographs, and these were exhibited together with the police photographs. It was the artworks that accompanied the archival images that created some of the unease that surrounded the exhibition. Why was it there? Should artists be inspired by crime scene photographs? Was the artwork good enough to earn its place alongside these archival masterpieces? The exhibition demanded that we address some of these questions. Can crime scenes be art? Can they provide the basis for creativity, experimentation, citation, and play? Can it be too soon for some of these creative endeavours? And if so, what is the appropriate waiting period? Lindy Chamberlain is the victim of Australia's most notorious miscarriage of justice. In 1980, her baby Azaria was taken by a dingo, a wild Australian native dog, from the family's tent during a camping trip, and Lindy and Michael Chamberlain, Azaria's parents, were tried and convicted of murder and later acquitted, exonerated and compensated. Following her conviction, Lindy Chamberlain was imprisoned where she gave birth to another child who was separated from her several days after she was born. In the decades following her exoneration, Lindy Chamberlain came to an arrangement with the National Library of Australia and the National Museum of Australia, each of which she chose to care for the papers and material artefacts that she accumulated as a result of her daughter's death and the coronial and criminal processes that followed, as well as the Royal Commission held to investigate her conviction, as the Royal Commission that led to her ultimate acquittal. The National Museum regards the Chamberlain Collection as, quote, one of the most significant collections to be entrusted to the museum's care, unquote. On permanent display as part of the dashboard of the Chamberlain's car. And this photograph, it's not a very good photograph, but it's from the museum. And this inset here is the way that you view it in the vitrine in the museum. There's a magnifying glass, and so you can see through the magnifying glass a close-up of some greater detail than you can see on the rest of this small piece of metal. This is part of the dashboard of the Chamberlain's car, which was subject to forensic examination. The forensic pathologist who examined it testified that she found blood spatter consistent with Azaria's throat having been cut. This was the notorious Arterial Spray that was later discredited as one of the many evidentiary errors made in that case. The forensic scientists working for the subsequent Royal Commission found that this spray had been applied at the time the car was manufactured, and it did contain iron, but it did not come from blood, and it was used as a form of sound insulation. In this museum cabinet, visitors can see this crucial item of evidence that was used both to convict and to acquit Lindy Chamberlain. Nevertheless, in the museum, the case is curated as a mystery central to Australian history and identity, and, quote, as a story from the emotional heart of Australia. And those of you who are not familiar with this case should know that this case was enormously influential at that time and absolutely gripped the entire Australian population, and was in no way only of interest to specialists or lawyers or scientists. So, of course, from a legal perspective, the case is not a mystery. The Chamberlains were acquitted and exonerated, and a fourth coronial inquest, which closed in 2012, concluded that Azaria had been taken by a wild dingo. This leads me to ask whether evidentiary items recontextualised in the context of national identity and memory acquire new qualities, unconnected to the outcome of legal processes. Acknowledging public debate that the collection is distasteful, mawkish, or that it is too soon to warrant such a central historical position, my project asks whether and how such a collection, comprising documents, articles of clothing, bedding, dingo paw prints, courtroom exhibit tags, and other evidentiary objects, might continue to have probative value after law's work has concluded. The collection was acquired directly from Lindy's personal archive, and also leads me to ask whether different ethical precepts are engaged by the manner in which the evidentiary artefacts enter the cultural field. Is Lindy's personal archive ethically distinct from other cultural manifestations of evidence related to Azaria's death? I might add that Chamberlain's car itself, which has long been regarded as the crime scene and which was taken for forensic examination and not returned until many years later, was last year acquired by the museum from Michael Chamberlain, who had restored it. So this is a photograph of a family on the way to this camping trip. You can see Lindy, she's holding Azaria as a baby, and their two other sons, Aidan and Regan, standing there. This is a photograph of the car parked in front of Uluru, which is an enormous rock in the centre of Australia, where the family had been camping when Azaria was taken by dingo. These artefacts, okay, so this is the car now that it's been acquired by the museum. These artefacts are so heavily loaded with meanings which, when pressed, turn out to be nothing. What is this car? It was a crime scene, and then it wasn't. As evidence, it once proved murder, and then it didn't. It used to be a modest, messy and dirty family car, and now it is this gleaming yellow jewel with the ironic license plate, you see, forensic. It didn't look like this when Azaria died, but it is nevertheless a recognisable relic from Australia's recent past. Most Australians who are alive in the 1980s would be able to tell you something about this case, this family and this car. In the National Library of Australia, the Chamberlain Papers fill 70 boxes. It's now moved from the museum to the library. When Lindy Chamberlain was in Berrima prison following her conviction, thousands of people sent her letters and cards. After her acquittal and release from prison, thousands more wrote to her. In total, Lindy received 20,000 letters from strangers. With the assistance of her parents and her then husband Michael, she collected and arranged the letters according to her own system. For instance, hostile letters, which were usually anonymous, might be classified as nasty or nut. Later, Lindy sold all of the letters, together with her personal papers relating to her miscarriage of justice, to the National Library of Australia, which sought to retain the letters and also for distinctive classifications. Their original archivist, the archivist who acquired the collection, was called Adrian Cunningham, and he asserted that these papers reveal, quote, the depth of emotional involvement in the Chamberlain case experienced by countless thousands of ordinary Australians, unquote. The Chamberlain Papers are a literal archive of feelings about motherhood, love, loss and faith, feelings about science and justice and law and evidence. There are other scholars who have written about the letters to Lindy and their contents. The Chamberlain Papers also provide evidence of Lindy's personal relationship with her papers. Cunningham explains that prior to Azaria's death, Lindy was only a marginally more retentive record keeper than the average person, but that her experiences transformed her into an obsessive record keeper. Michael Chamberlain, the former husband, was a professional member of the Australian Society of Archivists, and Cunningham speculates upon the role he may have played in instigating Lindy's auto-archiving practices. Whilst, of course, Lindy's ongoing accumulation of papers relating to Azaria, a discipline that she continues today, is motivated by her desire to remember and honour her daughter, Cunningham writes that her persistent collecting and the decision of the Chamberlain family to sell the papers to a public institution responds to their knowledge of the symbolic significance of their litigation in Australian collective memory. Anyone seeking access to the Lindy Chamberlain Papers needs to seek permission from Lindy herself, which is facilitated by the archivist who cares for that collection in the National Library of Australia. Primarily, the papers are accessed by scholars. However, at present, sorry, that's not a very clear photo, at present they are also being used by the Australian playwright Alana Valentine, who's writing a play to be called Letters to Lindy, and which will open in Sydney later this year. Valentine spoke to me about the process she went through in order to commence and complete the work, and which required her to obtain permission from Lindy Chamberlain Creighton and also from all of the copyright holders of the letters, by which she meant their authors, many of whom had forgotten that they'd written that letter, and more of whom were surprised to learn that Lindy had kept the letters and later placed them into a national collection. Whilst all of these people are, I understand, supportive of Valentine's theatre project, their response shows another facet of the afterlife of crime. Criminal evidence and other ephemera relating to criminal cases, such as the letters to Lindy, doesn't just dissolve or disappear at the end of the legal process. Where it goes and what might be done with it gives rise to ethical, legal, cultural and historical challenges. In October of this year, the Museum of London will open a new exhibition titled The Crime Museum Uncovered. The Crime Museum is the collection held by London's Metropolitan Police at New Scotland Yard. The Crime Museum is closed to the public. The Museum of London, in a complex collaboration with the Metropolitan Police Service and the Mayor's Office for Policing and Crime, is curating an exhibition of objects and artefacts from that museum, including some of London's most notorious crimes and policing investigations. I spoke to the curators recently and was struck by the degree to which they were reflecting on questions about ethics, voyeurism, legality and affect. They have given deep thought to what they might show and how they might show it. There are also things they say they cannot or will not show, but they feel they need to explain to visitors why some items will not be on display. For these curators, the exhibition is not only to show some of the evidentiary items held by the Crime Museum, it is about the Crime Museum itself as an institution and some of the ongoing challenges and debates about preserving crime's afterlife. They are conscious about the effect that the exhibition would have upon visitors, and also they want to achieve a certain impact. They want visitors to be self-reflective about what they have seen, what they might have learned from it, and how it made them feel. This brings me to my next and last example from my own scholarship, researching the case of Mundara Smith, which culminated in my book, which is called Captive Images. It's a bad copy of the cover of the book. Okay, Smith was on trial for robbing a bank. Security photographs were taken during the robbery, and 2 police officers testified at his trial that they recognised Smith from the photos. So let's have a look at some of the photos. This is Smith's mugshot when he was arrested. This is one of the photographs that was at this time the surveillance camera used a technology that took 1 still image every second after the camera was triggered by a staff member at the bank. So This is one of those stills. You can see the screens, the security screens in the bank are down. You can see there's someone standing here on the right with the hood. That's the person alleged to be Mandara Smith. There's someone lying down here on the ground. And the scribble in the corner, that's written by a police constable. His name is Constable Peterson. He writes the name Mandara Smith and signs it. That's the photograph from which that police officer said he recognised Smith. Peterson and another police officer both gave evidence that they knew Smith from their policing duties. They recognised him from the photographs, and that evidence of their recognition, together with the photographs themselves, were presented to the jury. There were alleged to be 4 perpetrators of this bank robbery, so this one here on the right is a different one. These are bank customers, 2 elderly men who you'll see in a minute kind of bravely take on these bank robbers. You can see there's someone lying down on the ground. Just on the far right, that's the one who's alleged to be Smith, and it was alleged that he was the lookout during the robbery, and the other 3 committed the robbery. One of them jumped over the counter before the screens came down. They sold about $16,000 Australian dollars. It's about, at that time, about 5,000 pounds sterling. Okay, here are the other 3 ones who are not alleged to be Smith walking out of the bank. You can see one of them's got white gloves on. And this photograph you can see on the right wearing a baseball cap is the one who's alleged to be Smith. Okay, so Mandara Smith's own confrontation with the evidence against him occurred during his police record of interview, which he gave voluntarily and without legal advice. He did not testify at his trials. After his arrest, Smith was interviewed by a police officer who showed him a photograph, this photograph, taken from the bank security camera. The police detective said to him, "Can you tell me who that person is?" And Smith replied, "No, I can't. His face is all scrunched up. It looks like he's crying." The detective said, "Well, I suggest to you that the person in that photograph is in fact yourself. What can you tell me about that?" And Smith replied, "Doesn't look like me." At trial, Smith was convicted on the evidence of 2 police officers who testified that they recognised him in these images. Following his conviction, he appealed to the Court of Appeal and finally and successfully to the High Court of Australia, that's Australia's highest court, which quashed his conviction and ordered a retrial. The High Court ruled that the police evidence of identification was not relevant and therefore not admissible. His retrial occurred without the police evidence. The jury was simply shown the photographs and asked to decide whether, beyond any reasonable doubt, they were photographs of Smith. Smith was sitting silently in the dock during his trial. The jury at the second trial were also given warnings about the dangers of cross-racial identification errors. Mandara Smith is Aboriginal. They acquitted him. The High Court ruling in Smith dramatically changed investigative and prosecutorial methods in cases where photographic evidence is available. Whilst I am also researching what has happened to photographic identification evidence as a result of the Smith case, my enduring interest in this case goes back to the nature of evidence itself. The photographer Deanne Arbus once said, "A photograph is a secret about a secret." I wonder what we can learn about crime from looking at evidence, and whether criminal evidence can be viewed outside or after the trial and with fresh questions. Several years ago, I sought access to these images and permission to reproduce them in my book. After a long and exasperating process, and I'll spare you the details, I found myself on the telephone with an officer from the New South Wales District Court Registry, and she had the Smith file open in front of her. I asked her to describe the photographs on the file, and she said, "Well, you can see the victim in both photos." And I asked her, "Which victim?" She replied, "Well, he's next to a big box and he's got a cap on in one photo and a hood on in the other." So I had to ask, "Why do you say he's the victim?" And she said, "Well, isn't he?" And I said, "No, he's alleged to be the perpetrator. He's alleged to be robbing that bank." "Oh," she replied, "it doesn't look like that." In the end, the court gave me 2 photographs, this one and this one. And the National Australia, which was the bank that was robbed, gave me permission to reproduce them. Seeing for the first time the high-quality photographs in the court files shocked me. Previously, I've been working with files from the High Court Appeal books. The images bore no resemblance to my expectations. The hooded figure didn't look like a bank robber. It did look like he was crying. Knowing that Smith had been acquitted at a retrial, I had no lawful way of knowing who this man was. Originating in a surveillance camera at a crime scene, now filed in a court registry, this image seemed traumatic and fraught. I made the decision not to reproduce 2 of the images in my book. I made the decision spontaneously, and I can't say that I followed any particular ethical pathway. Reproducing this image just seemed so obviously dangerous and wrong. Whilst the principles of open justice enabled me to see them, I was left in no doubt that these pictures should now be hidden from view, although obviously by showing them to you now I'm disclosing I need some help to work out why. After Smith's eventual acquittal, the rules of evidence had run out. These photographs were probative of nothing. According to law, the man in the image is not him. According to law, the photo still contains a secret. Who is this man? And since the fact in issue cannot be proven with admissible evidence, what should happen to this image now? We've grown comfortable with the notion that during a trial, evidence proves facts. What I think we need to develop, what I'm proposing, is an understanding of evidence after the facts. After proving issues in dispute, this evidence generates entirely different effects. It has the capacity for harm. It might be unfair, undignified, or humiliating to see it now, out of its original context. It might also be hugely instructive, interesting and inspirational. We might learn a great deal from this material and from the new ways that cultural practitioners might engage with this evidence. It might transform us into voyeurs or weirdos, or into people who have come uninvited into a crime scene. All of these are effects that I'm investigating when asking what is at stake when criminal evidence leads a cultural afterlife. Thank you. Also, thank you. Oh, that one's really bright. So I'm very happy to take any questions or comments or responses, and if anyone wants more information about any of these projects, I'm very happy to give it. There's only a few of you who I know and who I know what your interests are, but there's plenty of you who I don't recognise, so if you have another perspective on these materials, I'd be very interested to hear it.